It is my privilege to be here with Professor Heppner for our DCLI Legal Talk series, Faculty Scholarship in 10 Questions. I'm Dana Neacsu, the Director of DCLI. And it is my privilege to have here with me today Professor Richard Heppner, who holds a J.D. from Harvard and a Ph.D. in English Literature from Tufts University. 20 years ago, Richard, if I may, started his dissertation, Dominance in Dissolution, Discourses of Subjectivity in British Modernist Literature. What I would say in the right direction, because of the sources he mentioned. And I'm quoting.
Oh dear.
Modernism has been understood as a decadent aesthetic discourse of dominance. And now he's referencing Georgi Lukács,
Yes.
whom I deeply admire. A discourse focused on apolitical transcendence. And at this point, Richard mentions Terry Eagleton,
Sure.
another giant. And he ends on a lesser note, quoting Jean-François Lyotard for the meta-narrative, bringing in postmodernism.
Sure.
But that would be forgiven. Because your work is layered with meaning in the tradition of Justice Holmes and Justice Cardozo. And continuing at this level, as Justice Frankfurter said in an article from 1947, at the center of one of your more recent pieces, I would say that you are a wordsmith who understands that words are intellectual and moral currency, and they fluctuate as such. They are rooted in tradition, if they are legal words in the common law tradition. But you seem to be in the minority when you understand that they are meant to guide the action of men for the future, not for the past. Currently, our less democratic institution, the United States Supreme Court, has proven less inclined to guide the actions of men for the future through either demonstration or persuasion, but what I would say through expediency at the helm of ideological interest. And as such, they are using confusion and deception, or what I call fallacies of reason. We are very lucky to have you, Richard, because your jurisprudence is of the highest caliber. And now to bring you down to earth, I would say that the layers of meaning it contains are second only to a Viennese sake torte, Nichole.
Oh, wow.
So we are here to ask you to engage with us in deciphering some of your legal scholarship. And at this point, I'm going to ask you our first question. How would you like to introduce yourself?
Well, I mean, I can't compete with that introduction. But seriously, thank you very much for a surprisingly and impressively deep dive into
We are here to serve.
into my writing.
Invite other people to follow in.
There you go. There you go. Yeah, you may be the 5th person in the world to look at my dissertation after, my advisor and my dissertation committee and me. But really, thank you very much for that. I think you have indeed put your finger on a lot of the issues I'm trying to deal with, which are this sort of intersection of a kind of dominant view of language as a means of control versus a means of guidance, and the real fluctuations in the currency that occur, the changes in meaning that I think frustrate both attempts at control and guidance in both literary and legal texts. So yeah, thank you so much. I don't have a whole lot more to add. I'm excited to be a professor at Duquesne, so I think that's still a big part of what I want to introduce myself as. But otherwise, I can't top that. Thank you.
We're excited to have you and very, very lucky.
I'm excited to be here.
The second question, what inspires you to write?
we've already addressed that, but I mean, I know, I mean, I think that's, you know, I'll answer this biographically, I suppose. I'm inspired to write, because I have always been inspired to read, right? I think, the sort of close reading that I did as an English professor and working on my dissertation and writing in that genre has, I don't know if the right term is infected or inspired my legal writing as well, but you know, I find it to be an endlessly fascinating approach to trying to decipher legal meaning, cultural meaning, trying to disentangle and reentangle those left and right. And you know, would that I could do that without having to write it all out and figure it out. But for me, writing is very much a process of exploration. And that's probably the biggest reason I write, is to try and, you know, explore the questions that keep interesting me. I also find the questions really fun, right? So you mentioned my latest article is about that, and we'll talk about it later, but it's you know, I was just struck by how much was going on in these judicial opinions. And I just said to myself, I've got to sort of get my hands around that. And the only way I knew how to do that was to try to write my way through it.
Thank you. The third question, who are your favorite legal writers?
So I had these questions in advance, and I do have answers, but these are far from authoritative answers. I think my favorite legal writers are the ones that combine clarity, because so much of what I read legal scholarship and opinions for is to understand what the person's trying to say, and especially if what they're doing is explicating the law, understand what the law is. So combine clarity with a recognition of the rhetorical nature of language, right? That not an attempt to just sort of I guess falsely create an illusion of transparency, right? But transparency, but actually to recognize sort of the signifying role of language. So with all of that being said, not in my area at all, say in like criminal law, somebody that I like reading a lot would be like Oren Kerr. Oren Kerr is a professor. He writes incredibly clear, useful articles about criminal law. I have no use for articles about criminal law because I don't practice in it at all, but I find it so very useful as a model for scholarship for actually, you know, practicing law in the future. For anybody who's reading them, he's incredibly cited by judges for exactly that reason. But you know, this is a very sort of practical approach to law. On the other end of the spectrum, I like a lot of the crits, right? So say like Duncan Kennedy or what have you, with the who takes a real like structuralist approach to understanding law as a function in society. And again, still incredibly clear writing for complicated ideas, but having fun with it at the same time. So I like that. And then, you know, for judicial writing, I thought about this, tried to restrict myself to current people who are still on the bench. And I'm going to have to say like Elena Kagan is probably my favorite writer on the bench these days.
Biased? Was she the dean when you were there?
She was the dean when I was at Harvard, yes. And I did not have the foresight to take a class with her. In fact, I was sort of like, oh, she's administration. I don't want to take a class with the dean. I should have been more in the know at the time. Because she's brilliant. And she really is. And I honestly did not really realize this at the time. But she's great and super clear, and as well as being entertaining and approachable. And she changes up her style depending on the kind of opinion it is, depending on the likely audience for it, right? If it's a complicated procedural or ERISA case or something, it's more technical, still clear, but more technical and dry and spelling things out. If it's something that has to do with people's everyday lives and their rights, it's more accessible. Again, still legally, direct and correct and not always correct, but legally direct and clear, but also accessible and entertaining and tailored to a more general audience. So I always enjoy reading her opinions, whether I agree with them or not. I often agree with them.
Thank you. And what pieces of your scholarship would you like to talk about today?
Well, you've displayed
Some of them.
some of them here, yes, and already mentioned a bunch of them. I mean,
Feel free to, if you want, I have my own copies.
oh my goodness. Well, I mean, I suppose the most recent one is, okay, over here. This is probably the most fun one I've written, I think. At least I had the most fun with it. It's this article called Rooted. What is it called? It's called Rooted.
Metaphors and Judicial Philosophy.
Metaphors and Judicial Philosophy and Artists versus District of Columbia. So this is my latest article. It's about a 2018 Supreme Court case called Artists versus District of Columbia. It is a civil procedure case, not typically the most gripping of topics. It is a case about whether, when a case is filed in federal court based on diversity of jurisdiction, or supplemental jurisdiction, it pauses the statute of limitations for the state court claims. So a fairly dry technical issue. It matters a lot in real practice. People lose their claims if their statute of limitations has disappeared. So it's a practical, useful issue that people need a clear answer on. So that's why the Supreme Court is granting it. But it's not something that's gripping headlines, right?
I have to tell you that my thesis in law school was on the statutes of limitations.
Well, there you go.
So this is a gripping.
Well, I mean, it makes great difference in the everyday practice of law, obviously, right? But it's not a hot button social issue or what have you.
It could be, and you made it.
Well, I hope so. I think there are underlying hot button social issues that come out, even in what would otherwise be a fairly dry opinion.
If you don't mind, tell us the distinction between the two interpretations that you focus on, Gorsuch and Ginsburg.
Sure. So the case has a majority opinion by Justice Ginsburg, one of her last, and she was sort of a civil procedure maven on the Supreme Court while she was there, and the dissent by Justice Gorsuch, not really one of his sources, but in his starting out in his career on the Supreme Court, second year, I think. This is a 2018 opinion. So Justice Ginsburg, bottom line, holds that the statute of limitations is paused or tolled while a case is pending in federal court, so that if the case eventually gets dismissed, you have however much time remained on your statute of limitations to go refile it in state court. Justice Gorsuch would have held that the statute of limitations continues to run, and if the time runs out while you're in federal court, you only have a brief 30-day grace period that's in the statute to file your
Unfortunately, if I
case in
may
state court.
say something,
Mhm.
none of them used your clarity of language.
Well, thank you.
So let's go and tell us, so now confuse us.
Okay.
Both Ginsburg and Gorsuch didn't explain the issues like you did.
Well, thank you. All of my understanding is derived from them, so I think they did, but I spent a lot of time on the opinion too. So, so both of them chose to discuss this issue of statutes of limitations, not just in terms of parsing the language of the statute or looking at the policies or reasons for statutes of limitations or things like that, but they both ended up, and this is why I focused on it, employing a lot of metaphorical language to describe their view of how this ought to work. So Justice Ginsburg's approach uses some very familiar metaphors. She refers to statute of limitations as a clock. You pause the clock or you stop the clock. It's like a sporting event, not soccer, but other sporting events where you stop the clock. And then you restart it later. So it's this sort of mechanistic metaphor. And she says that this is an off-the-shelf way of Congress passing laws in this area. They often use a sort of off the shelf, stop the clock or pause the clock mechanistic way of handling things. So that's the metaphor that she uses to get to that holding that the statute of limitations is paused.
And the concept was tolling, correct?
Yes, the concept is tolling. What does it mean to toll the statute of limitations? Yes.
So instead of just saying it's paused,
Right.
we went through all this description.
Exactly. And to be fair, tolling is a weird word, right? This is one of those things that once you go to law school, you learn what tolling means. And it usually means pausing a statute of limitations or pausing a time limit. But that's not a word that anybody uses in plain language, right? Nobody talks about tolling things like that for the most part. And so that's why this was viewed as a somewhat ambiguous question. And indeed, Justice Gorsuch thought tolling meant something else, right? He thought tolling meant essentially to stop, as in sort of like kind of for whom the bell tolls sort of thing. That's another meaning of tolling entirely, but that's the approach he took, and he thought that and used entirely different metaphors to get there, that tolling would mean to stop the statute of limitations, that it would kind of end while when the federal case is filed. And to reach that conclusion, he treated the question of what does tolling mean as a sort of legal historical question, and looked back in his mind at English common law and different approaches to different kinds of statutes of limitations, depending on what the reason was for why the statute of limitations was being paused or not, etc. And he said that there was a sort of common law tradition from England where when the reason for stopping the statute of limitations was that somebody had chosen the wrong court, then you would only give them this little grace period instead of the full amount afterwards. And to reach that conclusion, he used another familiar metaphor, which is that when Congress writes a statute and they transplant an idea from the common law to the code, to the legislative code, that transplanting brings the old soil with it, right? So this is the image of a plant being uprooted, and it's got a root ball of dirt that brings it with it. And so he said when they use the concept of tolling, they transplanted it from one place to another, and it brought along this old meaning of what it means to toll. So I spent a lot of time in the articles tracing out where this comes from. It comes from the Felix Frankfurter article you mentioned. And why and how Justice Gorsuch uses this sort of organic metaphor as opposed to Justice Ginsburg's mechanistic metaphors.
The problem, I think, is emblematic for the way our current Supreme Court justices decide to pick and choose interpretations, because Frankfurter does not have this conclusion. He may use the same words.
Exactly.
For him, words are meant to guide action in the future. And whatever you bring in to understand context. And he's very clear in what you said. The context depends on whether the language is for ordinary people or for professionals.
Indeed, yes. So
there are other implications.
Right. For Frankfurter, when he uses this metaphor of bringing the old transplanting and bringing the old soil along, it's about Congress litigating in a specialized area and bringing along the technical language of that, of that area. So exactly. Jargon or what have you, we apply the, contextual meaning of that, not some other meaning. This is not an area with technical jargonistic meanings aside from the legal ones, which is to say the whole legal tradition, right? But nonetheless, Justice Gorsuch is relying on this metaphor. He uses it a ton. So one of the things about Justice Gorsuch that I actually do enjoy is he really goes all in on his rhetorical approaches. So he ends up talking in this opinion about, transplanting the root ball, but then he says, we should be looking in a different field. And, he talks about ecosystems and plants, all, as metaphorical ways of, I think you're suggesting this too, being somewhat disingenuous, right, to reach this conclusion that he wants to reach,
almost
couching it in that naturalistic
although he
Yeah.
doesn't recognize climate change. So all the environmental ecosystem approach is very disingenuous.
Well, I mean, I think that's true. I think it is disingenuous, or maybe to put it a different way, and maybe get back to the Terry Eagleton that we mentioned earlier, right? It's mythical, right?
Yes.
It's about
Dominance.
it is about dominance, and it's about a mythical tradition of common law and a sort of agrarian, idealistic and idealistic, British common law tradition, very much looking backwards, right? Not really scientific, much more about sort of the vibe of the common law and England and tradition and all this sort of stuff, which I think then moves into a ton of other approaches that the Supreme Court has started taking. And this is what you were talking about earlier, right? We now have an approach to asking whether rights are deeply rooted in our history and tradition, right? That's the new watchword, thanks to the conservative Supreme Court. And I think that even though those words are not Gorsuch's, I think he definitely paved the way for it, or at least fits right into it, with the kind of rhetoric that he uses.
Yes, an ideological take on words, which should not be.
Exactly.
Thank you so very much. So we are moving along.
Okay.
What are the main ideas behind your scholarship? If we can, we already touched upon it.
Sure.
So if there is a main idea, if you are focused,
Mhm.
like if you whether you have a project
Mhm. Mhm.
that you are building, and
Right. I mean, I think I'm definitely still in the process of discovering what the main idea is. Sort of like I said, I need to write the articles to figure out what it is I want to say and what I mean. I definitely have main concerns, right? Main questions that I keep asking, and they're very much about, I guess, how you can have practical, useful, judicial decision making that is nonetheless enacted through language, right? Which is what it has to be, and thus, to get sort of deconstructive about it, is necessarily going to be self-contradictory at some point, right? And how we kind of can't forget those self-contradictions, or pretend that when you find one, it is necessarily a flaw, right? I think that one thing that's happened a lot lately is the conservative legal movements have picked up on a lot of the old sort of left, let's deconstruct power kind of approaches, and said, oh, look, we can find contradictions as well, and so now we're going to deconstruct stuff from the right, and that's fine, that's perfectly legitimate. But I think it is worth remembering that just because you find a contradiction doesn't mean that the whole idea is out the window, right, or is useless for the law. So I'm not sure, exactly where I'm going with all of these issues yet, but that kind of central question of what do you do with the necessary disconnect between the language within which the law gets expressed by judges and legislatures, but judges tend to do more interesting things with language than legislatures, I think. But what do you do with that necessary disconnect between the language and the meaning, however we take that, whether it's intended or emergent from the opinions themselves?
I wish you good luck, because I sense the elegance of your writing is almost as useful as what you are writing, because we need to have people read something, and if they can connect, if the reader can connect with a text, or they can enjoy, they can go with it, I think you do a much better job at educating rather than just say something harsh, as I'm in the mold of saying, and people are repelled and they won't go along because it's not their cup of tea. So I do appreciate your work.
Thank you very much. I think I don't know if you're right about my writing. I hope that's the case. I think that is true of good legal writing. It is both, you know, clear and laying down the law, but it is also always persuasive and always attractive, right? I mean, that's one of the things I do like about Justice Gorsuch's writing, even if I disagree with him on how he's using it, is he is very much a good model of that, making things seem like a natural, good reading of the law, right? And that's unavoidable, and I think it's worth noting when it's done well, because it is a real part of legal scholarship and opinion writing.
And I think that's why we have to call whatever is by its own name, because there's too much deception. And I like the fact that you talked about transparency. And
Absolutely.
there's very little transparency. It's more confusion than transparency at the Supreme Court level. The sixth question, what does it add, so your scholarship, to the existing body of literature in your field?
Oh, tons, of course.
Good.
To give the law school answer, sort of, it depends. It depends how you define the field, right? I mean, a couple of other articles I've written were a little more doctrinally focused. They were actually about how judges decide issues about what's appealable and appealability. You know, so a very kind of in the weeds, we ought to treat the collateral order doctrine for appeals differently than we do, that kind of thing. You know, make it more of a standard than a rule, et cetera. So I hope that gives rise to some practical, actual, useful, you know, guidance about how to decide these kind of issues. But then, you know, as I say, it depends how you define the field. I like to think of my field as being somewhere at the intersection of practical procedural law and a larger kind of social, or dare I say, literary kind of approach to these legal questions. Law and literature is not a big field these days, but I think is maybe going to see a little bit of a resurgence as we see more attempts to really kind of grapple with the different kinds of linguistic formulations we get out of the Supreme Court and elsewhere. So I hope I'm contributing to that as well. You know, focusing on the signifier, right? Focusing on the means by which these power plays get enacted. Not just, although not forgetting the power plays that are getting enacted at the same time.
So maybe you were thinking about a law and literature class in the future?
I guess I would love to teach a law and literature class at some point. It's always in the back of my head. Yeah.
That's wonderful. How do you think the publication of your scholarship has affected your teaching and the scholarship that you're engaged with so far?
Mm-hmm. Yeah, so in some ways, you know, this kind of reading that I'm talking about in this latest article doesn't show up in your civil procedure class, right? There's too much in the civil procedure class just to get through clearing away the language to make it as crystal clear as possible and what have you, right? So this kind of approach does not come up there. On the other hand, I teach a federal courts class as well, which is in some ways sort of advanced civ pro / advanced common law kind of stuff. And there very often we spend a lot of time, you know, parsing the specific unusual language of a statute or an opinion to try and figure out, you know, what it means. So like in Fed courts, we just did section 1983, which allows you to sue people who are acting under color of state law. And under color of state law is essentially a weird metaphor, right? It kind of means while flying the flag of the state. It might mean being an official person who is enforcing the state law, but it doesn't have to be. You could be purporting to enforce the state law, or you could be purporting to do something that is allowed by state law. And we spend a lot of time, and I think my scholarship has influenced my approach to this, thinking about, well, wait a minute, where do these terms come from. This is a 19th century law, right, from 1871. So you need to look back at what these things meant at the time, but not in just a sort of originalist, oh, now we know this is exactly what it means, because even then, these were metaphors already, right? They did not have a single fixed meaning, and it's important to kind of keep that in mind.
I'm going to add an extra question because you mentioned something about going through the topics, going through the material. And I think this is another very interesting moment for us as teachers, but also as jurists, ChatGPT. So ChatGPT will allow, going through the material. So their debates. Are teachers going to be superfluous?
Right.
You have a ChatGPT going through every single rule, and summarizing it and explaining. And I think what you're doing is magnificent, and I think this is going to put Duquesne on the map, because you are not simply going through the material, but because of your erudition, you are actually helping people to understand meanings and to understand the importance, even misusing ideologies.
Sure.
Dominance and power. So how do you see yourself vis-a-vis ChatGPT and your teaching?
Yeah, absolutely. Like every law professor and every professor out there, the initial thing is, oh no, right? Is ChatGPT going to answer all of my exam questions, and I won't be able to, ask useful exam questions anymore. But I think that's a pretty narrow way to look at it, short-term way to look at it. I'm leaning towards thinking that actually having the existence of AI and machine learning and non-conscious entities that can nonetheless create text that is full of meaning, right? Which is kind of a bit mind-blowing in and of itself. Because a fundamental thing that we do, whether we're interpreting a contract or interpreting a statute or we're talking to somebody on the phone, is we think to ourselves, okay, these are the words that they have used. What did they mean by it, right? And with ChatGPT, it didn't mean anything by it, right? And it's just
patterns.
It's just patterns, right? There is not a consciousness behind it that had a meaning. But if you dispense with that entirely, then what does anything mean, right? If you dispense with the idea that there's a consciousness behind it. In some ways, it's not unlike trying to interpret statutes, though, right? Because Congress has no single intent, even though we talk about it all the time, right? Legislatures, the tons of people passing the laws have, at least 100 different intents behind them. So we're left parsing the language to see, well, if one person said this, what would they mean? And in some ways, that's how we interpret ChatGPT as well. So my sort of long-term view is that actually this kind of close attention to reading and the kind of literary reading that I'm excited about is, I hope, going to become even more important, right? That you still need to be able to do the mechanistic application of a rule, because at least so far, ChatGPT tends to make things up, right? It's not always good at applying the rules and things like that. But even if it gets better at doing that, sort of parsing out what the implications are of some explicit statement, I think are still going to require that kind of, again, attention to the signifier, literary kind of reading. Maybe even more so than it did before, right?
Exactly.
I think logic and rule application are central to the law, obviously, but kind of surprisingly, we're starting to see ways that can be automated, and I don't know if it will ever completely be so, because new stuff always comes up and what have you. But to the extent that it does get a little more automated, the role of the lawyer is going to change, and it's going to be more about parsing the gray areas and the implications and the rhetoric and even the metaphors that show up. And at least so far, large language models and what have you are not able to do that. Maybe someday, these things are improving exponentially, so who knows? But I see that as the role we still have. Yeah.
So I totally agree with you. Is that the number of meaning that belongs to the human mind and not to the computer, and that reflective thinking that we are going to use computers and machines to help us and increase the reflective thinking, and rather than be scared of machines, we need to embrace them because we know they are just mere tools.
100%.
And all we need is just become more and more thoughtful.
Yep. I will also say they are incredibly fun. Like I think this is an important part of sort of legal learning and lifelong learning is, rather than being afraid of them, which I think we could do as a profession, not to uncritically embrace them, but to play with them, right? I mean, I think they are incredibly fun, and there's a lot to be said for that. And that's how you learn stuff. And that's how students learn, and that's how lawyers will continue to learn, and the profession will continue to grow. So I agree. We can't, lock them away, but we can't just be afraid of them either, right? We can't just only approach them with caution.
Absolutely. Thank you. Moving along. So what are you working on right now?
I'm working on two things right now, both of which I think of as very fun, actually. So the one thing I'm working on is I am rereading the Charles Dickens novel Bleak House.
Oh my God, that
famous, Charles Dickens novel, obviously generally viewed as being all about how horrible the legal system is, right?
Thank you for not saying how horrible the mother was.
That's right. But yeah, it's all about, in addition to Lady Deadluck, it's all about the Court of Chancery and how terrible it is, and all the lawyers in the book eat up all the fees, and everybody just spends their whole lives pushing papers around, and nothing good ever happens. And it's all about,
worse than Kafka's.
Yes, it's like it's Kafkaesque, right? And I read Bleak House when I was in graduate school, and I wrote a very short paper about it that was about the law in Bleak House, though I had no intention of going to law school at the time. And it was about how, to my mind, it wasn't just critical of legal process, and then in fact, it had some insights about how the law can be useful and helpful, and can sort of change the identities of people and change the ownership of property and all these sorts of, in a way that actually improves things and makes things better, right? Not just churning up, using up, everybody's lives, in a Kafkaesque way. But that's not a common reading of Bleak House. And so one of the things I'm sort of thinking about is as I'm rereading it, is turning this into a sort of revisitation kind of defense of Bleak House, or as trying to wrench it away from just being a watchword for the evils of procedure in law. So that's one project I'm working on right now.
Read it.
Well, so would I. I'll let you know how it works out.
Yes, and we could have a book club about it. I used to have it as the first mandatory reading for my class in legal research once upon a time.
Oh yeah, it is huge.
It's
a giant book. I mean, it's a great book. Yes.
Some people like me, so that's one piece, and the other.
Oh, and then the other thing I'm working on, as I said, is sort of fun. Is this jurisdiction game that I've been working on with students. So the idea here is a table, like a board game, based on some of the rules that one learns in civil procedure. And like I said, I think one of the best ways to learn is by having fun with something, and taking a game like approach, or a gamifying approach, as they say, to learning. The idea here is that it is this game that I've been working on with a group of students in a workshop here all year, turns the civil procedure rules, or really actually the jurisdictional rules and laws, into the rules of the game. So not just sort of trivia game is something, often you think about Trivial Pursuit style game, you do flashcards essentially, but actually using the jurisdictional rules to play the game. So that has been great fun working on this with students in the workshop here at Duquesne. I've had 5 or 6 students throughout the year, and we've really got like a map where you have personal jurisdiction in different states, and you move your tokens around and you create minimum contacts to establish personal jurisdiction and other ways to establish subject matter jurisdiction and things. And it is very, very nerdy, right? But I think actually quite fun. And I hope to, start deploying it next year in my civil procedure class, and also write up an article or two about the process of turning these rules into a more fun game. So that's the other sort of project I've been working on lately.
If you need a digital space, whenever you are ready to make it public, please use us.
Oh, absolutely.
We'll have the
Yes.
digital
Yes. I'm
copies.
looking forward to, I think I very much want to kind of distribute it as widely as possible. So making a digitally sort of, in the game industry, they call it print to play, right? You sort of make the game pieces digitally available, and then people can do it. I think I definitely want to distribute as sort of open educational resource.
That's wonderful. And again, something that Duquesne Klein Law School should be proud of.
Absolutely.
So what would you like to work on next?
Oh boy, well, the difference between what I'm working on now and what I'd like to work on next is probably not, there's not much of a difference, right? I mean, I think, as I say, right now I'm working on this Bleak House piece, and I'll probably present that this summer, and that'll be my next, article. But then probably after that, it is the game is probably the next step after that. And who knows where I'm going to go. Somebody will come out with some opinion that really grabs my attention, and I'll close read that or what have you.
I think you're very lucky if you can say that what you would like to work is what you're working on.
Well, as I say, I the only way I figure out what it is I want to say is by trying to write it, right? So I just find the area that's interesting, and then bang away at it for a while. I'm not good at planning out the 10-year progress, right? And process.
The final question: what would you like to share with your students as a final thought?
Oh dear. My students, so with my students, we only have a week left, and they get plenty of my thoughts already about exam prep and what have you. But maybe, I think maybe one of the morals that I would draw from this conversation is that there is an importance to having fun with what you're doing in law school. Law school in general can feel like a real slog. It can feel like you're just cramming, rules into your brain and then regurgitating them and turning yourself kind of into a, logic machine, right? To get back to sort of the ChatGPT thing. Although ChatGPT is not always logical.
And it makes things up.
Yes, exactly. Makes things up. But as I say, I think that, sort of the message that I often try to impart to students is that you can have fun with this stuff. Like, there are rules to be learned and rules to be applied, situations to apply them, but that's no way to get through law school, and that's no way to get through being a lawyer, right? So remember to have fun with it, whether it is, in enjoying the process of writing and editing and using judicious metaphors when the time comes, whether it is in playing with new tools that show up, electronically and exploring that kind of advent of AI, whether it is, playing a board game that has something or nothing to do with law school. That's probably the takeaway that I try to encourage. Otherwise, what are we even doing here?
And in the process, saving the planet.
Sure.
So
I've got no problem with saving the planet.
So here we are at the end of our DCLI Legal Talk series for this year. And I'm here to invite our colleagues to join us and explain their scholarship and teaching philosophy to our Duquesne students or incoming students. So thank you again, Richard.
Well, thank you so much. I had no idea I was going to be the concluding message for the whole program.
For this year.
For this year, right? But this was so much fun.
Thank you.
This is such a great program, and I do hope we continue it next year and pull more people in it when I have more stuff to talk about.
Yes,
Come and talk about it again.
I would love that very much.
Great.
Thank you.
Thank you, Donna.